This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes.
And at page 27 of my remember all teachers are coming.
No, this is a different point that has been raised. This is not there. So this is the point is different. Connected with that point, not connected with the SLST, because there may be so many matters with that point. And if it appears that it is to be heard on 12th, I'll place it on 12th. Yes. Right. Right. Yes.
When is fundamentally different point, no doubt.
Absolutely.
When
the main
survives. It's fundamentally different.
Provided it survives.
Yes.
Yes. Right.
Well, at page 27 of my this is the rules, my lord. Rule 2 and within 11 portion, my lord. Rule 2K, page 27. What is an interview list? Interview list in respect of SLST state level selection test means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score, which is that is score for written examination and TET. TET is not applicable for us written examination. And academic score in the ratio of 1:1.6. So, my lord, this is the interview list, written examination score and academic score in the ratio of 1:6. Now, my lord,
it is not 1:6. It is 1.6.
1.
So it's a different
1:1.6.
merit list in respect of SLST state level selection test means in case of post for list of candidates for vacancy wise on the basis of merit, which shall mean suitable to what has been stated in Rule 2(1)A marks obtained in oral interview, lecture demonstration, and prior teaching experience. So, my lord, my case is prior teaching experience should be awarded at the time of preparation of the final merit panel, considering the marks of written score, interview score, and lecture demonstration, and thereafter prior teaching, not at the stage of interview for calling a candidate for interview.
What is the marks, full marks of the examination?
100.
And the breakup?
Yes, my lord, for that schedule to page 36.
36. Written examination 60. Educational qualification is 10. 70. Prior teaching 10. 80. Oral 10. 90. Lecture demonstration 100 marks.
So, my lord, I say this written examination marks and academic score will be considered for calling a candidate for interview. Thereafter, after the interview, at the time of preparation of the final merit list, the prior teaching experience marks.
Let's see. Today, 2 applications are not on record. First. Second, the written examination marks have not been declared. So, we'll post this after.
No difficulty.
Right.
Well, only thing, my lord, why I am apprehending. Today, the results will be published in all probabilities.
All right.
If the results are being published, calculating these 10 marks, then, my lord, entire thing will be.
They have not yet calculated written examination. Today, the result, if it is published, it is only for the written examination.
No problem. Let that assurance be given.
No, they can. How can he give assurance?
No, my lord. What I am telling your lordship, the candidates directly went to the commission. The commission says the result that will be published calculating the written examination marks, academic score, and prior teaching experience.
But that is true. That's true. He is right, because that's the law requires.
The result that will be published today.
Yes.
But this is not the result. The wording is not the result. It is
spread marks.
No, it's a interview list.
All right. So
interview
if it
list should be comprised of what things are there under 2K. Dr. May kindly have a look at that.
Yes.
Kindly see. Interview list in respect of the SLST means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called. All these parts not that much important. On merit for oral interview and lecture demonstration category wise. Now, this is the important. On the basis of preliminary merit score. Kindly pause for 1 minute. what is statutory preliminary merit score that has been defined within the bracket? That is score from written test and or TET. Now here and or, because for up to upper primary, they get a teacher eligibility test. So that is kind of, I would say, educational, how to teach, they get that marks. So that's come under TET. And for us, it's a written test. Kindly read this: written test and academic score. Now, what is the academic score? Kindly straightaway kindly come to, there is a
Schedule
defined under schedule 2. Well, under schedule, may I just say and thereafter show. There are three things: A, B, C. A equals to 9, 10. B equals to 11, 12. C equals to upper primary, which is completely different because then central government, NCT, all others comes. Now we here come under A and B. Kindly come A and B. Under A, there is a bucket of the academics. Under 2, this academics has two components. Component number 1, what is course in the educational institutions, and component number 2 is prior teaching experience. Therefore, the interview list, which has to be on the basis of 1.6:1. That means if there are 100 vacancies, they will call 160%. That's the ratio. That has to be on the basis of statutory prescription. Now, interesting part is, what possibly my learned friend might like to show is that under 2K, after 2K, there is a definition is of merit list. Now, this is one rule, caters to all the categories. Now, if I put 3 categories, 9, 10, 11, 12, upper primary. For upper primary, it is completely different. For them, they get it last. Why? Maybe the logic is they get the TET, unlike we don't get it. So for us, that is 9, 10 and 11, 12, under the bucket of the academics, prior teaching experience comes. So, this is and no, of course, he has not finished. Just to give, in case Lordship finds that, in case there is a, because my learned friend might like to show the definitions, in case your Lordship finds that there is a kind of any conflicting view in any way, kindly take a look at definition rule 2, because everywhere, my lord, this is a very fundamental, that all definitions are, well, I would not use my own words, it's there in the rule itself. 2.1 in the rules, unless the context otherwise requires. So all definitions are contextual.
My lord, I am appearing for the SSC. We have to make the interpretation, not the candidates first.
No, Mr. Bandabadda, we suffered a lot. We lost our job.
We know that, but I have to make my, suffered a lot. You have to make an application. Allow us. We just not that. Don't, let's serially. Let's go by serially.
Mr. Bandabadda, nobody is shutting you out.
I understand.
And I am going to hear you.
But I understand, but not this.
Let him make his submission.
About our conditions also.
Yes, you make your submission. I'll hear the commission also. It's not that the commission will not be heard.
Well, the very core principle of, if there is a conflict of little bit of divergence between the definition clause and the direct controlling clause. Controlling clause is the schedule itself, schedule 2 itself. In that case, the principle of unless otherwise requires has to be taken into consideration. Now, what is the little bit of conflict? Little bit of conflict, Lordship may see it, actually not a conflict, it's a superficial conflict. That 2K talks about the interview list, clear cut. And for 9, 10, 11, 12, it clearly mentions that the preliminary merit score means 2 components, academic score and the written test. That's all. Now, what is the academic score for that, my lord? That schedule 2, under the bucket of the academics. Here the word there is here academic score. Academic is an adjective. But thereafter in the schedule 2, they have used the academics, which is in plural, which is a bucket. Under the bucket, they have put the, my lord, the prior teaching there itself. Now, my learned friend might like to show the definition, next definition of merit list, that is in conflict. But that's, my lord, it's a superficial, that there is no conflict. Merit list simply defines 2 things. There is basically 2 definitions. Kindly have a look at merit list. Merit list in respect of the SLST state level selection test means, this is the first meaning. In case of posts, a list of candidates prepared category wise But this is the first. And second, on the basis of merit, now which shall mean. So now this part is actually not defining merit list. This part is on the basis of merit means what? Shall mean in addition to what has been stated in rule 2 1K, marks obtained in oral interview, lecture demonstrations, prior teaching experience, and shall. So here prior teaching experience is there. But for upper primary, can you have a look schedule 2C. So for C, they get it 5 marks because they get TET marks. We don't get it. It is not. No, I'm trying to say that rule-making authority recognized that situations are different. For 9-10, they have made for academics under 2 pillars, the qualifications and the prior teaching experience. And that is in sync with the rule. He is not questioning the virus of it. I'm trying to say that. He is saying that by way of an interpretation itself, that they should get it. I say the schedule doesn't say so. But that's my preliminary submissions. And there are judgments by the Honorable Supreme Court that even for shortlisting, priority that can be done. It's a very recent judgment.
Can I make my submissions?
No, the petitioner has not even proceeded. Let him place his case.
Then why Mr. Dhar was started to submit?
It was
too worried. I mean,
it was.
What too worried?
It's all right. It's all right. I'll
Mr. Dhar, don't pass that stuff comment. Do not try to hijack everyone's case.
No, I'm.
My lord, here he is. They are making this submission, and in the Supreme Court they are saying this act is bad. This is the whole problem of that.
Petitioner.
My case,
Contradictory.
your lordship has seen the rule and as well as definition rule and the schedule. Well, the intention of legislature in any legislature cannot be to cause injustice to one group and justice to another. My lord, the whole intention of providing prior teaching experience, my lord, that has also been stated by the defendant is the object is to get better teacher to teach the students. This is the only possible, my lord, reason for introducing prior teaching experience. Now, my lord, this prior teaching experience should not be awarded in a manner so as to cause injustice to other candidates who do not have them. Because, my lord, previously, in the 2007 recruitment,
this batch of or this writ petition has been filed by a batch of candidates who are absolute freshers. Yes.
My lord, previously in 2007, there was recruitment rules for SSC, my lord, there was a prior teaching experience, but a separate percentage of seats, 10% of total seats were reserved for these in-service candidates to avail the benefit of prior teaching experience and like that nature. So, my lord, there was no injustice. Now, it has to be construed, my lord, harmoniously, definition clause and the schedule. Firstly, my lord, the definition clause very rightly stated that when prior teaching experience is to be given so that it does not cause any prejudice to any fresh candidate. Now, my lord, take a situation. A fresh candidate out of 60 scored 55 and a in-service candidate scored, my lord, 44, 46. Now, with this teaching experience, he get a call for interview and this candidate even securing more marks, my lord, in the written examination does not. That is why, taking this into consideration, my lord, the legislature thought it fit that this prior teaching experience is only for the object of getting a good quality teacher, nothing else. That marks has to be given at the time of preparation of final panel, not at the time of calling a candidate for interview, because that will cause injustice. That is why, my lord, 2L specifically.
It will cause injustice if it is at the interview stage and not at the final merit list stage. It will be injustice at any stage if it is given.
Injustice at any given stage, because it creates at the screening level, it creates a advantage to a group of class among a class.
Yesterday, this is what the issue that was placed by Mr. Bhattacharya.
Yes, my lord, that is one issue. I say even if these 10 marks can be given, take a situation, your lordship affirms that no, these 10 marks can be given for the object of getting a better teacher. Now the question will come, when will these 10 marks be given so as to mitigate the injustice that will be caused to the fresh candidates? That is the, my lord, that also I must say, my lord, the rule also provides that no injustice is caused to any fresh candidate. That is why these 10 marks are to be given at the time of preparation of the final panel. And, my lord, your lordship knows, if your lordship kindly comes to schedule 2.
Yes.
Page 36, my lord. Academics, it is only a heading, my lord, but it's specifically subhead. Academic is one heading. My lord, 2. Academic is one heading. Practicing experience is another heading. It's not that under academics, it is practicing experience. Under the column 2, there are two heads, academics and practicing experience. It's not that under academic, it is practicing experience.
I think factually, this is just place it. I think factually.
My lord, may I? My lord, one, if your lordship is A, written examination, Weimar mark 60, then 2 academics.
Yes.
My lord, then after academics, it's being practice, completely different. And practicing experience, my lord, has no relation, has no relation with the academics.
See, one thing
Yes.
in this schedule 2, academics
Yes.
has been described under 2 heads, A and B. But in the upper primary, see,
Yes.
academic score is 10 separate,
Clearly
TET
different.
weightage 40.
Yes, my lord.
So they have tried to create some type of distinction
Yes.
by mentioning sub-clauses.
Because, my lord, in upper primary, first, there is nothing like written examination and practicing.
A prior teaching experience, 5 marks have been reserved.
For upper primary.
Yes,
But for TET, my lord, for written examination,
that is separate.
that is completely separate.
40 marks, that is separate.
Separate.
Yes.
What I am on in schedule 2, my lord, under 2 academic, there is A is educational qualification, B is practicing. That under academic, it's only educational qualification. Practicing experience is a completely different thing. And my lord, this rule
If 2 consists of A, then 2 will consist of B also.
2 is considered B, but the practicing experience does not include academics, my lord. That is why under 2 educational qualification, practicing. And my lord, it has to be read in consonance with rule 2L. My lord, if your lordship once again for my satisfaction comes
Yes,
to
yes, merit list you've placed.
my lord, this is my first point. This is my first point. My lord, my second point is your lordship has already seen the judgment passed by the Supreme Court. If your lordship kindly comes to page 131.
Petition 130.
Petition 130. My lord, 2 paragraphs I will read for you. Paragraph 45 and paragraph 76. The last question relates to the relief and whether it requires any modification.
Where are you reading, please?
Page 131, paragraph 45.
Yes.
So that void point.
Yes, yes.
And the last question relates to relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates where appointed must be terminated and they should be required to refund any salary. This part, tainted candidates for the time being is not in question because
nobody is raising this issue.
According to me, my lord, if your lordship has rightly called for the list, why? If your lordship goes through in details, the Supreme Court has defined who are the tainted candidates. Weimar mismatch. There is out of
whatever. We are not going into that.
For the present.
Yes, present we are not going.
My lord, paragraph 46. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void. My lord, I stop here for a moment. When a selection process has been declared null and void, everything which has flown from that selection process is void ab initio, is null and void. Nothing can be gained from that selection process which has been declared null and void.
All right.
Declared null and void due to the egregious violations of the anticipations which violated Article 14 and 16 of the Constitution. As such, the appointment of these candidates are cancelled. However, candidates who are already employed need not be. Here I am not
placing. All right.
So when a selection process, it's not only the appointments, my lord. A selection process, there is a difference between selection process and appointments. Once a selection process has been declared null and void, my lord, there is no scope of giving any benefit from that selection process.
Yes.
My lord, and that is why, my lord, these 2016 candidates who have lost their job because of the declaration of the selection process as null and void, they are not entitled to any sort of benefit. This is my first point. Second, if your lordship kindly sees, for candidates not found to be specifically tainted, are they not found to be specifically tainted? That they have to establish before your lordship first. Why I say this before your lordship? Because, my lord, this says not specifically.
Is the list published by the commission on the website?
There is something. A list has been published.
Is it there in the website?
Yes, yes, my lord. Yes, yes.
All right. So anybody can.
There is a
No.
Show me that my name is there.
a list has been published by the commission. But my lord, your lordship knows who are tainted has been defined by the Supreme Court. A Weimar mismatch, after expiry of panel, and out of panel. This list only contains candidates who have Weimar mismatch and out of panel. Candidates who have been appointed after expiry of panel. That is stated in paragraph 31. My lord, kindly come.
Where is the list available?
My lord, in the website that does not contain the name
Hey,
of candidates
Shailesh,
appointed.
please find out that list. Yes.
Mr. My lord, if you put that, if your lordship
You have a
kindly come
copy?
to paragraph 31.
Let me see once.
My lord, paragraph 31 of the my repetition one.
No, this at least I did not get it, so I'm not aware.
No,
Very well. I am not aware. Let me just see what is there. Paragraph 31.
paragraph 31, my lord, of the writ. Page 125.
আমাদের একটা ওয়াইফাই তে খুললে হবে।
Paragraph 31 of the judgment.
The judgment.
Yes.
Page 1, may I read? When WBSSC has also tried to justify extension of the term of panel, as noted above, the time period of 1 year specified in Rule 21 for the destruction of Weimar sheet coincides with the time period specified for the validity of the panel. There is no doubt that counseling process and appointments made to the post of assistant teacher for classes 9, 10 and 11, 12 were made after expiry of the panel. This is an illegal and contrary to the rules. Reliance on the orders of judgments of High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after expiry and validity of the panel would not have any significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment procedure, and that not specifically examining the question of appointment after expiry of the panel. So, the Supreme Court has clearly stated appointment made after expiry of the panel, counseling and appointments made after expiry of the panel is illegal. So that those candidates who have been appointed after expiry of panel and appointments made thereafter is illegal. So they cannot be considered.
The panel that has been published.
No, that
does it contain this one, the list that has been published?
Contain the name of any of the candidates who have been appointed after expiry of the panel. And I say this, my lord, with responsibility, with the addition that even a single candidate found after expiry of the panel, your lordship will dismiss me with exemplary cause for misleading this honorable court.
Well, I think my learned friend is going to completely.
Lord, can I make submissions?
No, sir. I'll hear the commission later on.
Achha.
Yes.
My lord, so
this. What is this?
We are sending it for a print. We had it yesterday.
Okay.
My lord, whatever be the list, I say this with responsibility. No, even a single candidate's name is featuring in that list. I have checked it personally. After expiry of panel, no candidate's name is there. So even for admitting there who are appearing before your lordship that they are not found to be tainted, they have to show that they have been appointed within the time period of the validity of the panel and not after expiry of the panel. Well, these are my 2 points. And
before the commission.
All right.
Before the commission will reply to this submission, may I add whatever points I have now so that they can reply in comprehensive?
Is it the same thing?
Item 2, my lord.
Yes, item 2. The
same argument, 2, 3 additional points.
All right. What is the number? আচ্ছা কি দেখুন। Yes, item 2. আসেনি? When did you file it? Yes, so it's not here.
I have only received can 1 and can 3 probably, and no can I have.
Well, I have served everyone, so
all applications to be circulated. Otherwise, nobody should be taken by surprise. What is the addition? দেখি 2 নম্বরে ফাইলটা একটু দিন না। Yes, yes.
Yesterday I have seen the entire argument on YouTube. So I'll not repeat whatever submitted yesterday also.
But yesterday's point was different.
Not really. One of the point is with me in my writ petition.
This one.
In yes, item 2.
Yesterday, the virus of the 10 marks, whether at all it can be given.
That is
or
one
not
of the
was
point
issue.
I have taken.
All right. Barring that, what is the other point?
Yes.
Today, another point is taken as to what stage the 10 mark is to be allotted.
One of the point in my petition.
What is the other point?
Now, let support the second contention. If you kindly take some the definition clause once, K and L, to decide at what stage.
Yes. Where is it in your petition?
In page 80.
80. Yes.
Now, K is the interview list. Means, in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration, category wise on the basis, then preliminary merit score, that is score from the written test and or TET for upper primary and academic score. Therefore, for preparation of interview list, they have to prepare it based on academic score, academic, not S. This is singular number, academic score. And then ratio. To find out whether teaching experience can be added prior to interview, can be ascertained from the next definition, merit list. Because this experience marks cannot be given 2 times, before interview and after interview. It has to be given either before interview or after interview. Now, merit list means, in case of post, a list of candidates prepared category wise on the basis of merit, which shall mean in addition to what? This is important. In addition to what has been stated in 2(1)K, the interview list. Therefore, what has been given in the interview list, in addition to that, marks obtained in oral interview, lecture demonstration, and prior teaching experience. Therefore, prior teaching experience must be in addition to what has been given in 2(1)K. Therefore, there is no scope for giving practicing teaching experience before interview.
All right.
This is one. Otherwise, they'll have to give 2 times. That is absurd. That is an absurd idea. Then rightly point out, so far upper primary is concerned, they have given the specific provision that they will give after. Now other parties. Challenge has been thrown yesterday. So far, awarding prior teaching experience of 10 marks. I have prepared a list. Rather, kindly see the vacancy notified. This is for class 9-10. Vacancies were 1375. So these are the number of person appointed in 16. So all of them will get 10 marks. Then 16, 11, 12, 164. Now kindly take some 2025, 11, 12, 390 in 11, 12. And vacancy 9-10 is 2988. Yesterday, Mr. Bhattacharya argued that class within class, that is one part. I am not on that. Kindly see they have invited application from all, including 16 candidates, all freshers. Now, if they award these 10 marks to the candidates having experience, then this experience of 9-10 is made applicable for 11-12 also. Then there is nobody from the freshers who will get appointed, because this vacancy is only 390. And these 10 marks of secondary experience of a teacher in secondary education is applicable for senior secondary also. Therefore, there will be nobody in the senior secondary having no experience will get a chance to be appointed. So for senior secondary, because 10 marks is the difference. Therefore, this is absolutely irrational, particularly when you are inviting application from all freshers. Now, let kindly takes up once again the distribution of marks at page rather than schedule 2, page 89. Why it is irrational? For one more reason.
Yes.
At this point, I have argued, in addition to that, whether prior teaching experience of secondary education can at all be given for senior secondary, because two different classes. Now, schedule 2 is the written examination, 60 marks. Then academic, percentage wise marks will be awarded. Then teaching experience. Now, kindly see schedule 2, clause A. Selection to the post of assistant teacher for class 9-10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, and then lecture demonstration. What is lecture demonstration? And for lecture demonstration, kindly see the marks 10. In lecture demonstration, they will ascertain who is the best experienced teacher can demonstrate his performance.
Is lecture demonstration defined anywhere?
Not really.
All right.
Not really. Basically, it's a demo class of a teacher that they can explain. Now, a person having teaching experience is getting 10 marks. Again, he will be given 10 marks in addition for demonstration of teaching. Whether that can be rational, and whether this again creates a class within class, and whether they can segregate those who are teaching in a private college, private school, because in terms of RT Act, school has been defined, and that includes private school also.
I was wondering why this challenge has not yet come.
Yes.
Maybe there are challenges, I do not know, because I have not got one. Central has come, but not private.
Yes. But what I...
Oh, maybe. I have not yet
and
gone through it.
State of West Bengal is recognizing all schools, and they are supposed to maintain standard of education in all schools similarly. Therefore, they cannot segregate one school with the other. But how can they decide that they will give 10 marks for the teachers who are serving in a government school?
That is not the issue over here, so I'll not...
That is one of the issue.
You have raised that issue?
Yes.
But you are not from... Are you from any private school?
Not really.
Are you a fresher?
I am challenging the provision.
You are challenging it whole hog. I understand, but then are you a fresher or are you...
I'm a fresher. At least I have not pleaded that I'm a teacher in a private school. I have not pleaded that.
You have not pleaded, and you have not appeared in the earlier examination also.
No,
2016, you have not appeared. You are a fresh candidate. All right.
But this is... oh, yes. Yes, 12 experience to bollam 12 provision oh but I was pressing that to demonstrate that for senior secondary is the same qualification they are seeking that. That is at page yes at page 90 the senior secondary lekha ache. Yes. That page 90
Yes.
after clause B, prior teaching experience of 10 marks, the line has been added at secondary level in a government or government aided or government sponsored school calculated on the basis of 2 marks each service in a substantive post. This is secondary. And senior secondary? Yes, sir. Yes, I'm sorry. This is for senior secondary. Even for senior secondary, they are taking experience of secondary education. And this will prejudice that chart I have handed over. Now let so far, Milad, other argument, Mr. Dashgupta has argued at length, Milad, the reason behind setting aside the entire selection process was that the court could not ascertain who are tainted and who are not. If they can today come with this solution that they have ascertained that these people are tainted, then my submission would be the others. The rest should be restored their service.
No, that is a different issue.
No,
Supreme
that's
Court
not
is there.
different. But if it is not, then till today they could not ascertain who are the rest candidates could not be
All
ascertained.
right. All right.
That's all. Milad.
You always have a turn, sir.
Oh, one more thing. The application.
And the government is still doing something.
Yes, the government is there, the commission is there, the private parties are there, all are there.
Should I make my
No, you make your submission.
if the Bandabandha can be there, allow me? On the subject, what have to do? Aim to
You take the microphone so that Mr. Bandyopadhyay can hear what you are submitting.
Oh, sorry, yes, no. Argued on tangent. But Mr. Shamin has argued that the rule is irrational. Void. Therefore, if it is void, no question of giving any marks. Today, and that is matter is fixed on 12.
Yes.
Should the matter be argued twice? Is that the court's intention? We can argue on the irrationality. Rationality. The court argued twice. Very well argued twice. If the clients can bear the traffic.
Yes, I was
If
just,
the clients can bear the traffic.
I resisted myself
Bear the traffic. Yes.
because all are unemployed. So think of the taxation upon the candidates. Whatever you submitted yesterday, that can be noted over here also.
That must have been gone down the ends by now.
Not at all. It's all there.
This is one point. I'll come to the irrational point again. Next point is null and void. Supreme Court said null and void. Therefore, no benefit can be taken.
Just tell me on this issue, what has been raised today is the stage at which this 10 marks can be given.
Yes.
First. Second, the new point has come whether it can be given only to the state-aided sponsored schools, state government schools,
Yes.
and why not to the private ones?
Yes.
And then
That on the affecting validity of the rule. No.
yes,
Let's have one by one.
yes,
Argument
yes,
of Mr. Dasgupta has been on the basis. Clearly say the rule is valid.
yes. That
So,
is one stage.
That is, if the rule is valid, then at what stage number
10
point
marks is to be
that's
given.
right.
And today the new issue challenging the virus
Hmm.
is that if that 10 marks is added to those candidates who got a chance earlier,
Hmm.
then the new ones will be prejudiced.
Very good. That is on the question validity of the
Yes,
rule.
yes,
Very good.
validity issue. If you want to reply on the 12th, I can hear you.
Yes.
Because it has been argued today for the first time. If you want to reply today, it's all right. If you want to reply on 12th, I'll hear you on 12th.
Certainly.
All right, no issues.
Now, may I deal with the then? And this null and void, everything should be. No benefit
No,
can
that
give.
argued yesterday also, that you can argue on 12th.
No. I don't adopt Mr. Dhaw's argument on that.
No, not adopting. Mr. Dasgupta, he submitted that it is null and void.
Yes.
Yesterday also the same thing was submitted.
Therefore, no benefit can be given, isn't
Yes,
it?
yes.
Now, may I start with that point?
Today or
Okay.
12th?
Well, why arguments are going on so in tangent?
Yes.
Can you see a Supreme Court order?
Yes.
Are they saying Supreme Court order is wrong? And my lord will sit in appeal about Supreme Court order and say order is wrong. Is that the argument? I want to know. At what stage our High Court has come down to? See the order of Supreme Court? Conclusion. Supreme Court is order. Next court see, this right. It is really page 131.
Yes, 131.
139. See the Supreme Court order.
Oh, in that one. Rahul.
See the conclusion. Null and void, no benefit can be given. No benefit can be given to the tainted candidates. Paragraph 45. You can make a distinction in respect of tainted candidates, untainted candidates. See, or candidates not specifically found to be tainted, entire selection process has been rightly declared null and void due to egregious violation of the illegalities which violated Article 1416. As such, appointments of those candidates are cancelled as such. Although they are not liable, they have not committed fraud. But because of some fraud committed by somebody else, they are being made to suffer. So, now next line. However, candidates who were already employed need not be asked to refund or this is benefit given. Supreme Court is giving benefit or not? See, candidates who were already employed need not be asked to refund or restitute any payment made to them. Is a wrong order? Wrong order.
Payment is not the issue, so do not raise this.
Not the issue. Benefit is being given by Supreme Court to the untainted candidates, although the process was null and void.
All right.
Being given, then argument, why the argument that no benefit can be given?
All right.
No, can you read on? Refund and what further rights are being given? Benefit. However, the services will be terminated. Well, is any payment made to them? However, the service will be terminated. Service will be terminated. But they have served for so many years or for a period, and they have taught. That taught is what they taught, what the university students, that is not null and void. They are working for and receiving benefit. Then the Supreme Court said, employed should not be asked to why they are not asked to refund the payments as the tainted candidates have been if the process is void. Why? Supreme Court passing a wrong order.
All right, next.
No. But can you see this argument must make?
All right, I have heard it.
Furthermore, no candidate can be appointed once then. Now we see another paragraph.
Yes.
Next paragraph, kindly see. No.
Please sit.
Paragraph
Please sit.
49. Here's another benefit. That these disabled candidates is mentioned in the previous paragraph will be allowed to participate in the first selection process if required with age name. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Further benefits are given by Supreme Court to untainted candidates. Supreme Court making a distinction between tainted and untainted candidates. And benefits are being given to the tainted candidates, although the selection process is null and void. And the argument is being, our High Court argument is made that if a selection process is null and void, no benefit can be given. Although they have said on the face of it, Supreme Court has given benefit.
All right, then.
This argument, may I go into this? The process may be null and void, but the employment is something else, contract of employment. If under a contract of employment, the employer has taken some benefit and some benefit has been given, the benefit is to be restored. If a contract becomes void, benefit received already restored. I'm not going to principle, I don't argue. I said this argument not open for my learned friend to argue in High Court to invite stricture from Supreme Court.
All right.
When Supreme Court has actually given the benefit to them. And whether under this benefit you are appearing in the next election case. Now, next point is that at what stage?
Yes.
Mark. My Lord, my humble submission is this. If my Lord's attention has been drawn to definition clause, is it?
Yes.
My Lord's attention has been drawn to definition clause and the schedule.
Yes.
Not to substantive part of the rules.
All right.
Not to substantive part of the rules. But in case of any ambiguity in the rules, substantive part has to be seen.
Yes, please show
and
me.
that can you see rule 11 or can you before that some other rule. Yes. Yes. After the definition clause ends, then we not kindly see other clause duly requested or meeting advertisement issued. Then we not kindly read 9. The substantive part of the rule. Form of application. The form of application for appointment shall be such as may be determined by the Central Commission from time to time. And the mode of submission of such form shall be exclusively online. The form of application given. Pro forma of the application shall be published Central Commission website. It has been published, not placed before the court. Here now there is specific clause regarding teaching experience. That is not placed. That has been suppressed. Now we have fees, etc. If you will have to see the form, I shall show you the form. See the form. Come to see the form. I show the form. We have a specific space. They say, are you working as an assistant teacher in any government school? Yeah, I don't. There's a question is there.
That is the issue. Why government school and not a private school?
Correct. That issue is being raised when that knowingly appeared in the examination under the rules and filled up the forms. At that time, they did not say, why are you asking me this experience? Whether this is a malified application, and come to that later on. This experience counts is also a form. Now, I'm not kindly see now. Next, substantive part. Then I'm omitting submission. 10. This method of SLST for selection of candidates and preparation of panel. I'm now assuming the rule is valid, as Madam said. Then only this question arises. Under the rules, what is provided is to be seen by law. That they say, according to their interpretation, this mark for the teacher experience should be given at the time of publication of merit list. And another view, as Mr. Dhar has published also, that 10 marks will be given at the time of publication of interview list. Now, interview list has been published or is to be published today. Whatever may be, it is ready. Now, we do not know whether the party who have examined, etc., they have given the 10 marks
or not.
Now, if they have given, then the question of objection arises. I think if they know it has been given, then they have to argue this. Number then what the court normally does, if a body, when the two interpretations are possible, they are assuming they are possible, which is not, I just show you also not. Even if possible, the interpretation or the view taken of the rules by the authority, if it is not totally irrational, that has to be accepted by the court.
Yes.
So they have not argued that this reading of the rule and giving the marks, etc., make it that the interpretation cannot be made by anybody, no reasonable person. Now, therefore, the approach is wrong.
All right.
Giving their views only is not enough. They have to say the other view is preposterous. No reasonable man can take in that view. That argument not made. That is the basic principle. Now let's see whether the argument has not been made and rightly not made, because rule expressly provides that the marks will be given when.
All right.
Now let's see 11 is the method of this substantive part. That nobody can depart from this. Method of SLST part, selection of candidate, preparation of panel. Once application submitted, Rule 10, Central Committee shall proper secure it. I'm omitting that. 2. This 2 is important. Central Commission, after receiving application form, shall prepare a list of candidates for the purpose of database preparation of the preparation of data. My copy is clear. My copy is clear. My copy preparation of database after making preliminary scrutiny of age and qualification of the candidates, which make them eligible to appear in the OMR and base test. The first list we published for who can appear in a written test. The first list. That is on the basis of age and scrutiny of the applications. Now, let's see when the second is coming into place. The stages. First is for written test. Now let's come. Then what happens the next stage? Then appoint etc. auditor, the appoint moderator, the appointed professor, etc. Scrutiny, etc. Then not time to Roman 5 B. Central Commission shall publish in its official website preliminary model answer keys after written test and may invite suggestions and the objections from the applicants. So after appearing a written test, this is very peculiar rule. After appearing in the written test, the examinees would know whether their answer is correct or not. Model answer is coming. It has come within 7 days in this case. So all these applicants have made, they know whether their written test is likely to succeed or not. Their model answers are there. Final model answer has to be prepared, given. Then objections are invited to the model answers. Objections are similar, shall be provided. Central Commission to publish a preliminary model answer keys up to within of written test and may invite suggestion, objection, etc. Then, provided that suggestion, objection must be submitted within 5 days after publication of such model answer keys and should be supported by at least 2 authentic academic publications. Submit. The Central Commission shall form a subject-wise expert committee comprising not less than 2 members of the rank, not lower than professor of college, university. Expert committee shall deal with the suggestions, objections, if any, received from any applicant. The decision of the committee shall be accepted by the Central Commission and shall be binding. Expert committee binding. So what is the model answers will be finally settled by expert committee. And that will be published. There's no mention in the writ petition that model answers have been given, and final model answers have also been published when. And they know what are the correct answers, this petitioner, and they can compare with their answers, and obviously they have found that their answers not correct. Their chance of likelihood of getting through the written test is remote.
Is there any cutoff marks?
Yes,
you have to get something in the written examination.
I'll coming to cutoff mark is later on coming to. Therefore, my point is, these petitioners have suppressed the fact when the model answer knows. I am instructed within 7 days from written test. I've given also in a list of dates, written test on 14 September or something, for different classes, different subjects. So, long before filing of the application, they knew whether their answers were as per the model answers and what was the chance of success. And it's obvious they realize the chance of success is remote because the answers, they now come with the application. And move the application when I'm pausing here. See the next stage. Next day. Central Commission shall finally upload 7 million. Central Commission finally upload on your website final model answers keyboard. This has been done. Final answer, which is binding on everybody. They can compare with theirs. Then age is very important. Thereafter, what happens? Central Commission shall prepare and publish in its website preliminary list with details of the candidates to be called for interview, is subject to verification of credentials and eligibility. Then category-wise, and on what basis? On the basis of preliminary merit score as defined in Rule 1K in the ratio of 1.6 into 1 for final vacancies, and that is 1.6 times here. Therefore, not this final the list for interview, which is due to be published today, I'm told, that everybody is saying so. That must be prepared on the basis of preliminary merit score as defined in Rule 1K. Now see Rule 1K. It's Rule 1K. It doesn't mention Rule 1F or L, 1K. Not L. Interview list in respect of SLST, etc. means in case of vacancies in the post of assistant teacher, a list of candidates prepared by Central Commission to be called on merit for oral interview and lecture demonstration category-wise on the basis of preliminary merit score, that is, some from written test and the TET for upper primary and academic score in the ratio of 1, etc. What is academic score? Now see, definition of academic score. Schedule. Yeah, see. But we're talking academic score. 36. Page. My page that clear. I'm not able. That's it's a 1 million now. Academic score. Academic scores. Schedule 2A. Schedule 2A. Election 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, lecture demonstration, determined by Central Commission in the following manner. That's the select sequence. That when the merit list comes, everything will be considered. How much it scored in them. Now the sequence of events is mentioned here. Now you will see academics. A written examination, 60 marks. First one. Academics has got two parts. Educational qualification, 10 marks. Similar based on what? Based on marks, graduation or post-graduation in subject for which applied, whichever is higher, according to the following formula. Similar is also 60%, 10 marks below. Nobody objected to do this. Nobody objected to this. Why do you different? Why 60% will get 10 marks? How is it relevant at the time of teaching? Nobody has said so. Number 6. No rounding allowed. Then B, prior teaching experience, 10 marks. There also it is stated 2 marks for each year of service. So maximum 10 marks can be given, provided there is 5 years of teaching experience. Now teaching experience, appointment are being made for government schools, government sponsored schools. And everybody knows, government schools, mode of education is different from private schools. They are not same. La Martiniere, St. Xavier's mode of teaching is not same as the government school. So they are asking for teacher of government schools and asking for teaching experience of government school teachers. Now, again, anybody said that the teaching experience in government sponsored school, etc., is not a matter of weightage in case of appointment in government schools. It is not a case of appointment in private schools that we are asking for your teaching experience in government schools. Then that could have been not relevant. Now, therefore, but I am first on sequence. Sequence part, prior teaching experience, 10 marks to be given after secondary. Then that is to be given before oral interview. So that is to be given before the final list of oral interview is published.
That means at the time of declaration of this
Yes.
2K, that is the interview list.
Yes.
The 10 marks is to be added.
Added. Then on the basis of that, the final list of persons who are to be called for interview will be published.
Yes.
Which is supposed to be due to be published today.
All right.
Now, if the examiner or the authority has proceeded on the basis, just 10 marks is to be given at this stage to before publication for preparation of final list of interview. Can that said to be irrational? That's the question. Now, this is rule clearly provides. First thing I submit, my lord, is most unfortunate, if I am submission, that definition has been shown, schedule has been shown, a substantive part of the rule, rule 11 has not been placed for your lordship. And that clearly says when this marks are to be given for teaching. Namely, I go back to the substantive part of the rules. Clearly showing me, Lord, it should be done. Let me not see, me not. Hey, this is me not. Something late I was reading.
Yes.
I read once more to say this is a
Yes.
If I can permit me to read just once more that I allow this repetition. Is for the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview, subject to the verification of credentials and eligibility. Category-wise, the list should be category-wise, and on the basis of what? On the basis of preliminary merit score as defined in 21K. Defined in 21K, not 21L. So, my lord, in my hamlet, it's very clear. Hands of the examiner are tired by the rules. They have to, as per the reading, they have to take into account the teaching experience marks, if available, to any students at the time of preparation of interview list. There's a second list to be published. First, written test list, now second interview list. Second, a further list to be published. Thereafter, he may not want to know. He will not kindly come to the list is finally published on website, then kindly come to me not 9. That's not the end of, that's not final, not end of the matter. To prepare the preliminary list as referred to above, marks obtained by the candidates were secured test position on the basis of ratio, etc. shall be the cut-off marks. Starting marks. The lowest mark is obtained, that will cut-off marks for a particular category. If, however, said cut-off mark is obtained by more than one candidate, all such candidates who have obtained the said cut-off mark shall be called for interview. This is the further scrutiny. Then, my lord, unless a candidate secures the cut-off mark in the particular category, he shall not be considered for that particular category in any subsequent stage of selection for that category, irrespective of his merit score obtained after interview in any other category. So, merit score to obtain even after interview will not be considered. That is similar if he not has reached the cut-off mark. And cut-off mark will be fixed, one of the lowest, after taking into consideration result of written test 60 marks and result of that academic code 10 marks for 10 marks for teaching and another 10 marks for I'm scheduled to that one. 10 marks 10 marks for 10 marks educational qualification. Educational qualification mark has to be taken 10 marks and primary teaching prior teaching. Both are to be, therefore, my lord, sum total of written test 60 marks maximum, and that is whatever the case. Then 10 marks maximum for academic success, first class, second class, whatever it may be. And third is teaching experience. All these categories are combined and known as academic. And Rule 11.8 clearly enjoins that all these have to be taken into account. Then final list for interviews to be prepared. And that final list will thereafter be vetted. Will be vetted and the cut-off mark is to be determined. Now, if I read on it. 10. Preliminary list of shortlisted candidates prepared Central Commission shall be forwarded to this one. So, therefore, after the scrutiny, the shortlisted list of person to interview published. That's the third list. Third list which is being published. Third short list. Thereafter, regional commissioner shall verify the credential eligibility of shortlisted candidates, appearing interview, etc. And I cannot do my portion for I just been checked and found incorrect, any incorrectness, etc. will be corrected. That provision is 11. Then commission during documentation in case of doubt, disability, etc. may refer to the competent medical authority, etc. That is to be checked. That is the provision for checking that. Then regional commission, verification document, etc. Veracity from the then upon verification, respective regional commission shall submit report. Must be 14 million. Upon verification, respective regional commission shall submit report to the central commission as to the outcome of the verification process. Then 11. Now 15. Thereafter, upon verification, etc. Thereafter, the Central Commission has prepared a consolidated interview list, which shall be published and to be forwarded to the interview board as specified in Schedule 3. Third time, a consolidated interview list and to be submitted to the board for after see the next clause. After interview board shall forward a detailed report to us after interview. Then interview will be taken of those persons who are in the list. And after interview board shall forward a detailed report to a central commission, which from the interview list and on the basis of report of interview board, prepare and publish a merit list category-wise on the basis of merit as per Schedule 2 Merit list shall contain the names of eligible candidates who have appeared for interview. Now let's see merit list schedule 2. Merit list preparation. Schedule 2. Then is the next lecture demonstration 10 marks will be taken. Then those who have been interviewed, my lord, they will have to give a lecture demonstration. They have to teach the students, attend the classroom and teach. And on the basis of their performance in the actual performance on the stage of teaching, they have 10 marks allotted and they will get the board. Lecture, as you call lecture demonstration, lecture to the students. And all these marks will be an appearance before the interview board is compulsory. Selection and post lecture on that basis, the merit list to be published thereafter. Now, this prior teaching experience marks is different. For the lower classes, is different. See. Now, Miller. Now, there in case of classes which are below, not 9 and 10, upper primary level, the primary teaching experience is 5 marks only.
Oh, here nobody is from the upper primary level, so we will not look at it right now.
Level,
upper primary, no candidate is here.
Upper primary something.
It is only 9, 10 and 11, 12.
For the upper primary level, and no concern with that. What I'm showing you, Milot, is a expert committee applied their mind and allotted different marks for different categories. It's not problem. Therefore, in my submission, Milot, on plain reading of the rules, there cannot be any doubt that if the interview list has been prepared by taking into account teaching experience, that will be totally unreasonable and nobody will take it. Now we have to assume the rule is valid, and all these parties have applied on the basis the rule is valid and rule is binding on them. And in the question form, application form, there's a clause. Are you working as assistant teacher in any aided sponsored schools under government? Question is there. Then again, next, experience count. Each completed year. Each completed year means 2 years. They know that. If the fresh candidates may have experience in government school teaching, may have.
How can that be? They must be appointed in some manner.
Previously appointed. Government school is not born in 2016.
Previously appointed, the age will be bar. How can they come? They cannot come.
No. Government schools are in existence from when?
If somebody is in existence or has taught, then the candidate will be quite aged.
Before 2016, there were government schools or not?
The age criteria will not match.
Age. That is an assumption. Therefore, my lord, those persons
cannot be given any chance.
No. Those persons who were in government school teaching as teacher, and there could be teachers of government school prior to
2016. 2016 selection process got cancelled. 2016. Right. So 10 years. Where from will they get this age benefit? They will not get. Only because those candidates suffered some problem. This is the reason this age relaxation is given.
Right.
Freshers are not getting.
Now, Lordship is going to rationality of the rules.
Yes.
Now, but the rationality rule, Lordship on the decide, I can make further argument. I made up with this. That at what stage a mark to be given, right or wrong, under the rules. That is my argument. First argument. And nobody has said this reading. And the funny thing is this. Today is the date of publication. And today application is being moved.
There are pending applications also. There are pending applications.
Pending. Today is become urgent because rule is being published today. And what is the effect of it?
It was filed very.
What is the effect?
It was filed.
I mentioned later anyway.
No, it was mentioned. The other bench was possibly hearing the matter. Now with the change of determination, it has come to this bench.
But whatever reason, Act of court can cause no prejudice to anybody.
Right.
Whatever reason, matter is being taken up today. And court will decide whether any order is called for on the date matter is being heard.
Yes.
But whoever faults may be.
Yes.
Now, when the final list to be published today, and court not knowing what methods they've applied, I'd ask them in the dark.
No, they have taken specific instruction from the commission's office, and they have been told that the marks will be added. Prior teaching experience marks will be added at the time of the publication of the written examination.
Where?
No, my lord, no.
Put that paragraph.
If the stand of the commission is that 10 marks is not added now,
Mr. Bandyopadhyay is there.
My lord, I will address it. I will address this point.
Only one thing.
Am I audible? My lord, am I audible?
I can hear you, Mr. Bandyopadhyay.
Only one point.
Can I place my case, my lord? There are hours and hours they are arguing. Give me chance, my lord, 5 or 10 minutes.
I will give you days and days, don't worry.
No, I do not want, my lord. This is not a
Yes,
case that
please.
hours and hours to be
Very
argued.
grateful to my learned senior Mr. Mitra, my lord, for placing Rule 11.8. Kindly come to Rule 11.8. There is one in the second line. There is one important.
Why haven't you placed
My
that?
lord, case is not only between the petitioner and the private respondents.
That. Relevant. It's the most relevant.
Case is not between the petitioner and the private respondents. What is the course of
Rule 11.8.
Yes.
Subject to verification of candidates and eligibility.
Yes.
This means, my lord, at the time of kindly consider this very important.
My lord, your lordship can
Filling
give
up
me
the
chance.
online application form, no document was uploaded with the application form, only the information. Now, till date, my lord, I have taken instruction, my clients are also present, that no notice has been given for calling the candidates for verification. Only after verification an interview list can be published. So today, as submitted by my learned senior Mr. Dhar, that today is date fixed for publication of interview list. It cannot be.
No.
It cannot be because
Yes, he is correct. He is correct. Mr. Dasgupta is correct.
না আমরা ফিরে দেখি বলুন আমি তো
স্যার আপনি কি শেষ করবেন আজকে না অন্যদিন করবেন
এক সেকেন্ড স্যার মাই লর্ড উইদাউট ভেরিফিকেশন देयर ক্যানট বি এনি ইন্টারভিউ লিস্ট
স্যার আপনি কি আজকে শেষ করবেন না অন্যদিন করবেন তাহলে আমি তো অন্য কাজ করে আসি
মাই লর্ড আই হ্যাভ প্লিডেড ইন প্যারাগ্রাফ 6 হোয়াট আই হ্যাভ সেড
প্যারাগ্রাফ 6 দেখি দাও এবার ঠিক বলে দাও your petitioner state the paragraph 6 can you read me not the petitioner visited the office of concerned respondent authority to gather information with regard to schedule, time, and procedure conducted for interview round. When the petitioners were informed that 10 marks out of 100 awarded for prior teaching would be given to candidates participating in the recruitment process before the interview round. So, who has said so? No. Let us come to pleading.
One thing.
No name anybody.
No, your submission is that the interview list that will be published will contain the 10 marks.
And paragraph 6 is to be ignored because the pleading has to be said.
Your submission is that the interview list will contain the 10 marks. This is your submission.
Interview list should contain.
Should contain. Just now you read out 8. It says subject to verification of credentials. The credentials have not been verified till date. How can the interview list be published?
That is new point argued.
No, it is you who placed this.
No, I have placed.
You have placed.
It is not done. Who said so?
The parties.
Who is not done?
Sir, your client has appeared in the written examination. Did you take instruction whether their credentials have been verified?
Please come.
They have not.
Please come back to the rules. Verification how to be done is also mentioned there.
This kindly give me 5 minutes. This all problems will be resolved. Give me 5 minutes. Give me 5. All confusing. Kindly give me 5 minutes. 5 or 10 minutes. Then kindly hear them. Give me 10 minutes.
Application.
Yes.
That will made at the time of filing a written test.
It has not been done.
Then written test list was published. And without verification.
Hey, this is the commission's way of functioning. What can be done?
No. We are not. Whatever Mr. Mitra is saying, that is no.
Kindly hear Mr. Bandyopadhyay.
Mr. Mitra's submission to this extent is not correct.
Certainly.
Let us hear.
10 minutes. This is just answering only this. Verification done at the stage of written test.
2 hours, they will take
Just
time.
formally done.
Let the commission say whether they have verified or not. Let us hear. Yes, Mr. Bandyopadhyay.
My lord, kindly see. I have 2 or 3 first, my lord, the objections.
Yes, please.
The read petition is not entertainable by this court at this stage.
Right.
because the read petitioners all appeared in the examinations.
Right.
And my lord, to this extent, I am citing a judgment, my lord, 2024 SCC Online 1511.
Yeah.
Paragraph 6. My lord, may I read, my lord?
Yes.
The contentions of the appellant are not acceptable. This has in fact been dealt with the High Court. The conditions stipulated in the corrigendum is no more amount to a change of the rules as has been argued with the. Moreover, the appellant was fully aware of the rules and those conditions under which he had participated. Once he has participated under a rule, he cannot challenge the rules to be unfair if the promotions have not been made as he would have wanted. This important aspect is the promotion have taken place as per. Now, once he has appeared, then my lord, he cannot challenge the rules. Second point, my lord. Similar, just I tell you, is very short. The fact is, in the Orunima Pal's case, entire rule was challenged. I mean, the entire rule that was dismissed, here dismissed, even in the Supreme Court, it was dismissed, excepting certain portion. Then, my lord, successful candidates, I mean, untainted teachers also filed so many petitions in Supreme Court. Either challenging the Orunima Pal's judgment and other judgment, also Article 32. Supreme Court is examining the entire rule. And that is fixed on 24th November.
This 2025 rule?
Yes.
Nobody has
Yes.
submitted this.
No, they have not said.
I said, Bharat, yesterday I did say. I
They
said
said.
that Purnima
Now, my lord, what I would be.
SLST dismissed, but whether this rule is under
Yes, yes. My lord, I will show. If your lordship give me time, I will.
some saying no, some saying yes. What does the court?
My lord, in that case, give me some time. I will show you the petitions also and whether there are submissions. My lord, may I just take it from me, my lord? Just take it from me. Please, Mr. Dasgupta, all you have taken time. My lord, the Supreme Court has said, kindly take it from me, on 24th November or whenever they met, entire thing would be scrutinized. Second, that is, I leave it to your lordships whether your lordships will examine it or not. I am telling your lordships the fact. Therefore, this is, blood, everything is under the scrutiny of the Supreme Court. Just I tell your lordships this. My lord, I will be requesting to your lordships that give a directions or to move them under Article 32 before the Supreme Court, because so many multiplicity of the litigations are not expected. Whole rule can be seen there. They can go under Article 32 also when this is being looked into. This is the one of the part of the matter objection, and also it will not be rather proper at this stage by the High Court to go into this. Third is a delay. Well, delay maybe 1 year delay, maybe 6 days delay is also factor. If at all, without waiving my submission that they cannot challenge the rule, they could have come earlier. They did not come earlier. Your lordship was still observing just a change of determinant. That is the last week. 3 or 4 months, they have not challenged it. Today, we are going to publish the only candidates who appeared in the written examination with their marks. Nothing more than that. Thereafter, the verification will be done within 7 days. 7 days or 10 days, just take it, at that time. This is one group. Only 11, 12 will be published today. 9 and 10 will be published within 2 or 3 days. But this argument I have also made in the Supreme Court also. Supreme Court has given us time, that's all right. You continue with this. Verification, etc. But then after verification, what stage is coming? Before interview? Yes, before interview. First, I have to verify that whether any teacher who has, any candidate who has applied and passed in the examination, whether he is eligible or not. Let's take it, there are some cases, we have given it, said it in the Supreme Court. Supreme Court has also given us the liberty. Some cases, maybe some tainted candidates have been missed. Let's just assume for argument's sake. But at the verification stage, we can also say, we can also detect them, cancel. Similarly, the untainted teacher who are claiming untainted teachers altogether, whether they are all untainted or not, that would be verified at the verification stage. After the verification stage is over, now Lord kindly come to the rules. The lordships have gone to the rules. Kindly come to Lord page.
স্যার আপনি আইটেম নাম্বার 2 না 3 তে বলছেন?
ভাই আমাকে তো যেটা বলছো যেটা চলছে লিস্টে দেখাচ্ছে সেটাই তো করছি। Anyway, subject is same. But inter 2K, kindly see 2K. Interview list. Interview list in respect of the SLST state level selection means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration categorized on the basis of the preliminary merit score from written test and or TT for Amrut so and so and academic score in the ratio of 16.1 final vacancies. And this academic score you are also will find here the policy schedule. Schedule 2. Well, along with the prior teaching experience. Therefore, interview this preliminary merit score and also academic score. Then you will also kindly see merit list. 2L. Merit list in respect of the SLST state level selection test means in case of post, a list of candidates prepared category wise on the basis of merit which shall mean and in addition to what has been stated in Rule 2K marks obtained in oral interview, lecture examination and prior teaching experience shall include all the eligible candidates. That is a wide definition. And at the time of preparing of the merit list, we will take into consideration all things, everything. That doesn't mean that the prior teaching experience is not included within the 2K, because it is within the academic. But that has been more clarified what Mr. Mitro was submitting under Rule 11K. Therefore, today before a lordship is 2K, today before a lordship is 2L, and today before a lordship is 11. That Mr. Mitro was submitting, that 11, Roman 8. The Central Commission shall prepare and publish its website a preliminary list with details of the candidates to be called for interview, subject to verification of credentials and eligibility, categorized on the basis of the preliminary merit score as defined in Rule 2(1)K in the ratio of 1.61. Malad, your lordship notes the rule of interpretation. There is a harmonious construction. And with the court object is not to destroy the rule. Court object is to preserve the iron quickly. Now, kindly similar, your lordship takes this chip very clear. First is written examination result, verification, then the academic score, then it comes below the interview. Interview what? That's a two stages are there, oral interview and the demonstration is there. This is the case. But there I cite one judgment to your lordship. Kindly take this. Give it. 2000, Justice Malar Mr. Dipanko, 2024 SCC online 3776. SCC online 3776.
SC 24 SCC online 377.
Kindly come to paragraph 6. The contentions of the appellants are not acceptable. This has in fact been dealt with by the High Court. The conditions stipulated in the corrigendum is no manner. Sorry, I am very sorry. Kindly excuse me, Miller. Kindly excuse me. I am very sorry. I am sorry. I have given a wrong citation and I was in 2024 SCC online 3776. Kindly come to paragraph 24. I'm very sorry. In state of Rajasthan versus Sannam Lodha, this court was considering whether absent a challenge to the law rule, this same could be read down answering in the negative Honorable R.B. Ravindra and J. So it is true that any provision of an enactment can be read down so as to erase the obnoxious or unconstitutional element in it or to bring it in conformity with the object of such enactment. Similarly, a rule forming part of an executive instruction can also be read down to save it from invalidity or to bring it in conformity with the above policy of the government. When courts find a rule to be defective or violative of the constitutional or statutory provision, they tend to save the rule wherever possible and practical by reading it down by a benevolent interpretation, rather than they declare it as unconstitutional or invalid. But such an occasion did not arise, and in this case, there is no challenge or to the validity of the Rule 5 so and so, and therefore of the view that in the absence of any challenge to the Rule so and so. Now let's come to the prayer of the petitions. Kindly see. Page 21. It is Ssc-র. A declaration. Kindly say declaration declaring that the respondent authority and its agents to abide by Rule 21K and Rule 21L of the West Bengal School Service Commission, appointed to so and so, and the rules to thereby awarding prior teaching experience after the interview round in connection to the recruitment process 2025. His interpretation is this should be done after the interview. Our interpretation of the rule is this, that it has to be done before interview. Therefore, he has not challenged the entire rule. He is asking the marks should be added after interview. And according to our rules, our interpretation is before that. Now, the next second B, a writ of in the nature of mandamus to issue commanding the response their agents, servants, subordinate employees, assigns not to award marks for prior teaching experience in calling a candidate for interview in connection to the recruitment process. Therefore, today, I don't know whether what is your lordship's mind is, whether your lordship is finally hearing the matter or we have to file an affidavit, no doubt about it. And at this juncture, the question of passing of interim order does not arise at all. That will absolutely allow the writ petition itself. Kindly remember one thing, we are running against the time. That is the whole difficulty we are seeing. Yes, that day also I was telling to your lordship's man. 31st December, I have to declare the result in terms of the Supreme Court's order. With great respect, I tell you, with great respect to your lordship, any type of intervention in this matter will nullify the order of the Supreme Court where 31st December 2025 has to be done. And prima facie, I have a case I have shown to your lordship. This is the case. And I will request and beseech to your lordships. I will rather beseech to your lordships in this matter. So many applications, so many writ petitions have been filed. Why they are avoiding Supreme Court now? That's much I am telling you. With a guarantee I am telling. Everyone is avoiding Supreme Court. Give them leave to file before the Supreme Court under Article 32.
Please
any sorts of
document. Please show me some document that this issue is pending before the Supreme Court and 24th is the date fixed for hearing of this.
In that case, kindly take it on 12th. I will show you.
Yes.
No, there are so many. Please show me.
The copy of the SLP is required to be produced before your lordship.
He showed something.
Let him show something.
Milord, I will show that the Orunima Pal's judgment, where Orunima Pal's judgment, the entire rule has been upheld by the division bench, was challenged by them.
This was placed yesterday.
I placed yesterday.
We placed it yesterday.
The exact thing should come to rest after. Because this 10 marks granting or not granting the division bench held, and it is not arbitrary.
My points have not been dealt with in Orunima Pal.
The question was whether that particular rule was arbitrary or not.
Was the rule under challenge?
Yes.
One order from my CAN application.
You have a copy of the no, this order. Have a copy? Please check up. Page 24, this line was placed yesterday.
And then 634.
1 minute, please. Page 24. Sixth sentence, the recruitment rules has not been challenged by any of the appellants.
That is not
incorrect.
Probably not correct.
See, this is the court's order.
Yesterday it was shown to your lordship. Yesterday it was shown to your lordship.
Line was also shown.
With respect.
And in the single page,
They will Mr. Bandyopadhyay showed it to your lordship.
Yes.
I wanted to
Right.
show the prayer of Orunima Pal.
Please see paragraph 28 of this division bench. Please see 28. It was.
But thereafter not proceeded with.
Yes.
No, before the division bench,
There is a difference.
There is a difference
Yes.
between not challenging at all
Right.
versus
And
I
abandoning
challenge,
it.
thereafter just a second. Challenge and thereafter I find I don't want to continue because of XYZ reasons which may not be suitable for me, so I give up.
Yes.
This was a case of given up, and that was recorded by the division bench.
my lord, all the councils.
Respect of one. In
My lord,
respect
kindly
of one
see.
candidate who's not a party over here.
Correct.
Right?
Correct.
So the court, when the litigant gives up the issue,
Yes.
the court doesn't have any scope and an occasion to
Look into that.
No, that is your lordship is absolutely correct.
Correct. No
My lord,
doubt.
your lordship is absolutely correct.
My lord, there
But
are-
what I am, my lord, that is your lordship is absolutely correct. My lord, whatever it may be, ultimately it will be decided by the Supreme Court. There, my lord, Article 32 petition is
after Mr.
Article 32 petition is
I
maintainable.
don't take soft copies.
Article 32 petition is also maintainable. They have moved so many Article 32 petitions.
What is pending in 20?
Because time is a very important factor here. That is the reason I am saying. Otherwise, I would not have argued this point, your lordship. Your lordship is having all jurisdiction powers, everything to examine whoever the litigant is approaching before your lordship. But here is the case, your lordship knows this, the entire thing, that if your lordship, then of course, if your lordship entertain the petition, we will file an affidavit, thereafter matter will be heard. But
No,
any
this is a
type of
point
entry,
of law. This is only interpretation. There is no affidavit to be filed because factually nobody is denying or
no,
disputing.
not only one thing, kindly record that I wanted to file an affidavit, but affidavit is not required. Your lordship makes this interpretation.
But according to me, everything is
I have to put on record all these documents. What your lordship is saying, where is these documents, where are that other documents that I have to place it before your lordship.
The Bandapata is correct. Your lordship kindly come to page 41
Of
my Can 1 of Ssc-র matter. Item number 3.
can one দিন তো দেখি
Can one din na?
Page?
Can one.
page 41
My lord, with your lordship's leave, may I go, my lord?
দেখি শিশির দাস
কেউ যাবেন না?
No, my lord, with your lordship's leave, may I go, my lord?
পিটিশনের নামটা দেখুন না
চলে যাচ্ছে কেন?
শ্রী দাস ক্যান ওয়ান এটা কোনটাতে
This is Can 1, your lordship.
স্যার একটু থাকুন।
পেছনটা দেখুন শিশির দাস
But every
My lord, with your lordship's leave, may I go, my lord? With your lordship's leave.
price of the Supreme
Can I go?
Court.
Can I go, my lord? With your lordship's leave, can I go, my lord?
yes Mr. বন্দ্যোপাধ্যায় certainly
My lord, duly obliged.
all right
Two is completely different. I tell you.
1 minute Mr. Sanyal was showing some 41
Sleep over page 41, 42. Have a look at 43 only.
yes 43
এর জব কত?
Operating portion, next page, page 44. The last paragraph. The matter need not be listed on 31st October or 31st October. Even if specific dates have been given in any of these batch of matters, as they would necessarily have to be heard together. We are informed that the results of the selection test held on 7th September 2025 and 14th September 2025 would tentatively be declared in the first week of November 20. List on 26th November 24.
26 is mentioned 24th
So, all these have been applied.
Oh, my lord.
oh 1 minute page 41 that you placed is a matter of Vivek Paria where is
Place that order? Yesterday also.
Vivek Paria was it placed
Yes, sir.
I cannot
We have given a copy of
So because every matter, a bunch of matters were heard by Justice Bhattacharya, the jurisdiction bench presided over justice. All points are
because Orunima Pal has been highlighted. I cannot recollect that now.
Yesterday Arunima Pal was highlighted.
Yes.
Division bench and several different. Vivek Paria, my lord, issue was whether there was a criteria 45% has to be
no.
there was no 45% or 50%.
Incorrect.
Challenging that division bench negate no the qualification fixed by the
And Mr. Mitra appeared for Vivek Paria before the High Court.
Listen, thing is whether this 10 marks
no
prior teaching experience, this issue was hard.
My lord, let the SLP's copy of the produce whether this 10 mark issue is in challenge in those SLP.
Even yesterday, the law, SLP copy.
Whether this 10 marks can be point of law grounds kindly sit down.
And
Showing one
an issue has been raised as to why do not you take it up before the Supreme Court, the whole thing.
Court fixed. But in fact, this should go before the Supreme Court.
Oh, I didn't see you. I missed. Just
Well, he just now came, Milan.
My lord, and Article 35 petition was used directly by one of the candidates. The Supreme Court deprecated, no, you go before the High Court first. And another matter, my lord, the High Court refused to entertain. Supreme Court said no. That is why, my lord, your lordship will find all are special leave petition, not a single Article 32. All are from special leave petition. Let the copy of the SLB, if their candidates are appearing,
in Vivek.
Let the copy of the SLB be produced before your
Vivek.
Yes, that is
Yesterday.
given.
Is it there in the file? All right, I'll check it up.
Point of law number 12, ground number 12. Now, other point is each point is pending before the Supreme Court. My legislature was asking that whether we are out of expiry of the panel appointed candidates or not. If so, they will be tainted. Now, please order the
1 minute. 1 minute. Vivek, SLP, which ground and
ground number 12.
ground 12.
Number 12.
All right.
I put a tick mark for the loss.
All right. All right.
Yesterday has been given for the SLP of Orunima. Orunima was hard with Vivek. I'll show you your losses there. It's a bunch of
Was Vivek's SLP given or not?
Look at all the matters are hard analogous.
No, but then is it in one matter only?
What happened? There are a bunch of petitions, hard and disposed of by the division bench. One SLP was taken together, another SLP was moved.
No, Orunima Paul's SLP was only restricted to certain points and Vivek was restricted to certain points.
The fact remains, the entire thing is pending before the Honorable Supreme Court.
The entire thing. There are issues.
This issue, the issue which is being heard.
Show me something.
Keep it at Monday and produce the document. Keep it at Monday.
The other points are we are not.
But why will the court look? The commission is there to look into it.
No, I'm showing to your lordship that everything is before the Supreme Court. Right.
Yes, and the commission is the authority to see who are in the panel, outside the panel, all these things.
Point was asked in this petition. Justice Bhattacharya in the single bench said we cannot do it because Supreme Court is in.
Yes, whatever
then
the
went on appeal.
Division.
Appeal court justice division bench presided over Justice Papabotto Chakraborty held the same view.
That has been challenged. That has been challenged by the list was challenged by tainted candidates. So we do not fall under those candidates. Completely different, my lord. Your lordship can consider the writ petition. It will be clear to your lordship.
yes.
It's considering about tainted candidates. Kindly see what was the issue, my lord. Kindly consider
Question of law. It's a question of law. State 10% of
yes, question of law. Then why it is pending before the Supreme Court? I also say it's a question of law.
And the operative portion you also put the order.
Well, kindly read the order, the issues raised in that writ petition. Completely different.
Candidates were allowed to continue their service, but they were appointed after expiry of the term, and their names do not feature in the list dated 30th August. This is exactly the submission of Mr. Dasgupta.
No, their submission is that the commission is to see who are tainted and not tainted.
He is arguing that these sort of candidates are coming within the zone of tainted. Yes, that submission. So this is the same argument.
No. That is completely separate and nothing has to nothing to do with the 10 marks. That is the eligibility factor which the commission will consider. Whether they are eligible or not eligible, that is not the issue.
Qualifications, not these ones.
No. The Supreme Court has said
that's one of
will be able.
Cannot be allowed at all.
Yeah, that is also an eligibility.
That's one of the points. The 2 points are involved.
So that the commission will see. That is not the issue.
They are arguing whatever argued before your law.
These are not very relevant. What is important is whether this 10-mark issue is pending before the Supreme Court. Please show. Yesterday. All right, I'll check it up.
My lord, may I?
And the issues also. In a very short and a concise manner. Otherwise, see the documents over here. Yesterday's.
My lord, see the judgment of division bench where this point was teaching 10 marks were raised or not. Please see paragraph 6.
Which one? Which judgment?
This is common sense judgment.
Orunima Paul?
Yes. See paragraph 6.
This 16th July's judgment?
Paragraph 6, I have shown. Yes, see. Then Paragraph 6, middle. Mr. Bhattacharya submitted because in the middle, it is submitted that prior teaching experience for 10 years was not an eligibility criteria in earlier notification. Moreover, the percentage of marks has been arbitrarily increased from 45 to 30. This is the second point, and made malafide make them disqualified. Other in terms of now, similar when this matter comes up before the High Court, I mean to the learned bench, what they're considering, what they're saying. No, but I think court is being misled. দেখো বার করে দাও ওইখানে কোর্ট হোল্ড করতে এখানে প্যারাগ্রাফ 34 paragraph 34 can you see now?
Paragraph 34 has been placed yesterday.
Yes.
Today also it has been placed, and one line is also there that the recruitment rule has not been challenged by any of the appellants.
But it's not challenged.
It is written over there.
দেখো
The sixth line from the top, page number 24.
My lordship may look at from this point of view. It is possible.
Yes.
There are
Awarding of marks. Awarding of 10 marks is a weightage.
No, page 24. Page 24 of the judgment.
Page 24, yes, 24.
Sixth line from the top.
Okay, lordship is absolutely correct. I've
24,
See,
yes.
what is passing through the court's mind?
Can I just conclude? I began. There are
The prior
just
teaching
conclude.
experience is
Okay,
an
not this-
important factor. If prior teaching is an important factor, the experienced teacher may impart education effectively and efficiently.
Next line.
Recruitment rule 225 has not been challenged by any of the applicants. I'm not challenged, but argument was made.
Suppose it is not under challenge, somebody comes up with an
Let me not challenge. Just see.
I have,
See, madam, has not been
I have an
challenged.
answer to that, and I don't want to take an extreme view. My lord, when
But
a
not-
rule particular, please, just not, let us not go back.
34 has been placed, Mr.
30,
Chatterjee.
30, 30.
I don't want
That
to,
has also, Mr. Bandhavada yesterday has
I
placed
don't want to
everything.
say, I do not want, please, I do not want to say in that way. Kindly see two things. I do think there is an every possibility, because I'm not going to say I'm 100% confident, but my hunch is there is a possibility that the entire virus of the rule may not be challenged before the Honorable Supreme Court. This is true. At the same time, this is also true that this is a unique situation, unlike other SLPs and civil appeal, where because of a gigantic nature of impact governing the matter, the Honorable Supreme Court is, without using the word monitor, is effectively, I'm using effectively trying to see that my order is actually complied with. So therefore, I do not say that if anyone questions the virus, lordship doesn't have power to enter it. I don't think. I think one can independently question virus, which is a purely point of law, possible, unless it is purely covered. But there is also a thing called a propriety. Now, when the Honorable Supreme Court, in a very unique manner, in this case, is trying to ensure it is complied with, what does it mean? It means we have delivered a judgment, that's the Honorable Supreme Court. Thereafter, X, Y, Z things were our directions. Are those directions being complied with? Now, at that juncture, I do not say that it's legally, I would be able to say that lordship doesn't have a power. Lordship has power. But even if lordship has power, lordship may afford to say, I don't want to enter at this stage because of propriety. It's not because lack of power. This is number one. Number two, if lordship wants to see this, because something has to be before your lordship shockingly wrong. There is a clear-cut judgment by the Honorable Supreme Court in 2024 involving this prior experience. It was by, now kindly have a look at there. This is, it's not page, no, it is not page. This is, kindly see, 2024 SCC online 3776.
It has been given by Mr. Bandhavada.
I know that, but the other para.
Para 45.
I have this. Kindly see, exact, this was.
Bandhavada cited this judgment on the part.
Yesterday this was
Let us
placed.
have
Today he cited.
Yes, I know that.
Para
For
45.
today. Oh, then it must be here. Yes, Allahabad University is here.
Yes, kindly
Here it is.
see
Yes.
paragraph E at page 3.
Yes.
Paragraph 2E. Kindly see the procedure. Well, there are synonymous words are always there. This is a judgment where the weightage, that's the prior experience, was used for the purpose of shortlisting even. That is pre, which is the case here. E. The procedure for shortlisting candidates for interview is given in the note to regulation 4.1, which provides for shortlisting on the basis of an academic score prepared in, kindly mark the academic score, identical case of ours, with table 3A for universities. Well, just pause. What is table 3? That is paragraph 40. Kindly come page 26, paragraph, page 26.
Yes.
Serial number 7. Teaching, postdoctoral experience, 10, 2 marks. Similar method. Now kindly come back to the same paragraph, 2F. So this table 3A, there also teaching experience was there, and 3B. Hence, for shortlisting candidates for the purposes of interview, Allahabad University would score candidates as per the criteria laid down in table 3A and the affiliated college, such and such. As per clause 7 of table 3A and 3B, 2 marks are to be granted to a candidate for every year of his or her teaching experience or postdoctoral experience. Since the contents of both the tables are similar, we propose to reproduce, they are reproduced. Then G, despite respondent number 1 fulfilling the eligibility criteria, she was not shortlisted for the interview as her score did not reach the cutoff marks. This happened because she was not awarded the marks under that 3A. Kindly straight away come paragraph 48. Because the division bench took a different view, single bench took a different view. The division bench view was set aside. Paragraph 48. We are also of the view that the criteria for shortlisting of candidates as engrafted in table 3 and 3B were in furtherance of the entire scheme of frame by the UGC for appointment on the post of assistant professor in university as well as in college. Clause 7 of table 3A and 3B, having direct relation with regulation 10, did not call for any observation from the division bench of the High Court of the nature noticed above. An aspirant satisfying the conditions in regulation 10 would be entitled to marks either for teaching experience or postdoctoral experience for which a cap of 10 marks is imposed. Regulation 10 on its very terms makes it clear that rendering a past service, well, this is important, law point. Rendering a past service is not a sine qua non for direct recruitment. If indeed a candidate has served in the past and answers all the conditions that regulation 10 envisages, read with clause 7 of table 3 and 3B, as the case may be, he or she would be entitled to marks for teaching experience. In such circumstances, we hold that the division bench completely erred in appreciating the contention issues in the proper perspective vis-a-vis this. Now, similar thing also 2025 Justice Gawai judgment in our professions. My lord, now if a lawyer wants to sit in the judicial examinations, a freshers, I have LLB, so therefore I am entitled.
The district judges.
Now experience of three. Kindly have a look at this judgment of Justice Gawai. This is Justice.
UPSCs.
Copy touch. Yes. Kindly take 2025 SCC online SC 1184. If I can just say my premise, I say that there is no reservation for freshers. So therefore, it's a competition. In a competition, selector has a right to choose, if the pool is available, whoever I think to be the best. Putting experience as a criteria as something which gives a leverage is recognized by the Honorable Supreme Court in variety of matters. Now this 25, kindly take my lord, paragraph 89 Roman 7 at page 32. Even the direction was that amend all the rules of all the high courts. Romans 7, last para. All the high courts and the state governments in the country shall amend the relevant service rules to the effect that candidate desires of appearing in the examinations for the post of civil judge, it's not district judge, civil judge junior division, must have practiced for a minimum period of 3 years to be eligible for the said examinations. Kindly my lord, contrast this way. A person desiring to sit in the examination, in this case, is not even be able to appear at all, unlike this case. A freshers who doesn't have a reservations, he would be able to participate. But he will not be getting
A job.
Yes, no, he will not be getting the experience marks.
That means he will not
But
get the
no,
job
if
also.
he's a brilliant, kindly look at this way. If he's a brilliant, in a sense, if his academic marks are much higher, then he will get. Kindly look at Mallet from a, I would say, from a point of view, because both sides may have a story. Both may be reasonable. Now it is Lordship would see which is more reasonable. One side is saying that our scope is being choked. That's the freshers. They are going to say this is choked. The other side is that there is a judicial recognition of experience and marks, and that is Justice Datta's judgment. So therefore, it is very well possible for a selector also to say that you must have some experience. Without doing so, they have diluted it. They said that if you have experience, if it is a prior, if it is in a government, because they mentioned in a government or aided school, then you will get 10 marks. Does it mean it is completely choked? My answer would be no. Yes, it is reduced, competition becomes more. But that is, my lord, that is for a reason which is not unreasonable. It is not unreasonable because in judicial examination, experience has been, because fundamentally.
Tell me something, if
Yes.
if the issue is pending before the Supreme Court, the court will not look
It is,
into it.
it is.
First, second, this issue, 10 marks. Other issues, it may be pending. The court is not concerned because that has not been placed.
We'll come back on 12.
That,
But I-
But also said,
but
Milord,
that is the first thing that
But
is
to say
staying in the
something
mind.
with a full confidence, then I have to get hold of
Somebody
these.
must be there
Yes,
having
yes.
documents to show.
Must be, my lord, I say this, that this teaching experience point is not pending before the Supreme Court.
SLP,
Not the SLP, the original lead petition.
Original, nothing.
They have to bring original lead petition in.
Yes, one is fixed on the 26th.
As well as the writ petition.
And what happens, that technically it might be possible that the point of when is not there, but prior experience was there, that is clear. Whether prior experience was there and that 10 marks is entitled, that is there, there is no doubt about it. Question is, these two things.
Why don't you all see, you all are filing so many applications, petitions and everything. Get some order from the Supreme Court.
Yes. Yes.
It permits
That's
the court to look into this issue.
That's the propriety.
This is the cause of action which was available to them, in the month of August.
My writ petition, my cause of action was not available.
He sat for the examination keeping his eyes closed.
But the rule says that there is a possibility that the 10 marks has to be given at the preparation of the panel. In my challenge, whether the 10 marks are to be given to 2016 cancelled appointees,
It is on 26 November. This is the ground.
Change to individual issues in the advertisement, right? Whether can be looked into by the High Court when the issue is pending before the Supreme
Well,
Court.
at this juncture,
Just take,
even an arbiter of division bench is binding on single bench.
you please get
Even
this
even-
type of orders.
even,
I am keeping it next week because 12th the matter is already fixed. In the meantime,
yes,
please,
on Monday.
This is the ground.
in the meantime, you try to get order from the
Please, Sadhukan, আমি এটা দেখাচ্ছি।
High Court to get it done.
SLP
Lord,
number
no will not do.
2082 দেখাচ্ছি। আমি দেখাচ্ছি, দেখে নিন।
nothing is pending before the Supreme Court.
Milord, Abhijit Sadhuka, I just now, got.
See, all different names are coming.
Difficulties, there are n number of matters. The only ploy of the petitioners are to come to your lordship's court at the last moment. They were of the rules, these rules were promulgated in the month of May 2025.
Somehow what they have failed to do directly, to do it indirectly, to
This is
accommodate
completely beyond their reading.
tainted candidates.
Completely beyond their reading.
What do they gain out of it?
That is, the gain is to stall the process.
What do they gain?
That is the only gain.
This is unfortunate.
Now that a
This is
commission is saying such thing, my lord. That means the commission, we are not equal to the commission.
This is a with all due respect, this is a political statement.
They are also
This is not expected from a commission.
anything out of the whole
That
thing.
shows that commission is not treating us equally.
Stall the process. They failed.
Much shows.
Not the matters.
The results are not
Kindly
declared.
visualize.
We do not
The
know what
Supreme
their
Court has
position is.
directed us. Mr. Chatterjee produced orders. It says, yes, please.
well, that would be the
Best
I
course
feel,
of
my lord,
action.
that would be the best course of action. We get hold of all the SLPs, copies and the orders.
Either keep
Otherwise,
it on
I'm
12
not saying
or
lordship
earlier.
doesn't have power. I say,
And whatever y'all rely upon, please circulate with the petitioners so that they also get come prepared. Otherwise, again, John,
I will give.
there is a timeline within which things are to be done.
Correct.
Diary number ta আছে
Kindly have a look at the one.
diary number
First, yes,
And instead of that,
has service of the cans been made to the commission?
I believe that this is not a application on 32 blood. That they must bring the writ petition in which it was originally challenged instead of the SLP. That SLP they cannot expand the scope of the writ petition. Therefore, they have to produce the writ petition. And the second issue that we do not want to jumble it.
Keep it on 10th and Monday even. Imagine one.
All that today.
They cannot come prepared.
Today my simple prayer is that the whatever issue pending is not so far this when at what stage this marks to be given is not pending for the Supreme Court. Now
What stage
today
to begin? That's right. That's right.
today they may publish the result or list of candidates. One line order is required from this court that whatever result they publish that would be subject to the result of the writ petition.
We are opposing them.
Otherwise,
No, it goes without saying.
goes
Opposing the
without
this will not prejudice anybody.
Yes,
That goes without
My lord,
saying.
even if your lordship
Lordship can
does
always
Yes.
ask.
even if your lordship does
No,
not
do not see from you
Issue-
this type of submission.
The time
is
limit
not
within-
expected. No,
he is
it's all right.
he is making this submission. He is not requesting
He
it.
is.
Point out only one sentence. I hold my
Ground
head.
date and ground line, same.
But only one sentence apropos the interim order that is being prayed. But in the notification itself, employment notification itself, it was made clear that the participation is without intending to create any equity or right to any
Yes.
party.
It goes without saying.
that is not subject
That
to
is
the
all right, but that is the ultimate. That is the ultimate. Empanelment does not create any right. It's that type of thing.
If anything is done today, that can be undone, number one.
Yes, yes.
Won't create any right.
That is always subject to the
Yes,
result of
always,
the
always.
petition.
Yes, kindly record.
Let's have a look at SLP or kindly have a look at the ground. Look,
8 and 9.
Kindly have a look at the
8
ground.
and
Yesterday it was not there.
No, yesterday it was not.
Who was
Well, let that be considered on 12th.
I think we should reserve our energy for
How
12.
many cans have you supplied to Mr. Bandyopadhyay?
I have also not received the
I have supplied to except state.
He is appearing for the state.
State, I
Then
Even below the commission has not received any application.
it,
Below the applications have also not been received by the commission.
hey, commission has not received your application.
Only can 5 I find.
Yes, the lucky one. What about your can? Please serve.
state I will give. The commission I have given.
No, commission has not got.
Can one, can one, can one.
Have the copy of the
one thing, all pleadings and copies should also be served upon us.
Yes.
They are ready.
Lordship may pass exactly the same order.
Yesterday that was passed earlier.
He has received all.
I cannot hear you, sir.
I'm on behalf of the intervening applicants, my lord.
Again, intervening applicant.
Yes, my lord. It is a can 4 of today's item number 2. I just want to indicate that, my lord, I am led by Dr. Maneka Guruswamy.
Yes.
She could not appear today, my lord, due to some difficulty. My lord heard yesterday the same application. I just want to indicate that, yes. I just want.
Appearance 12th it will be heard.
Yes, my lord.
যে যে মামলাগুলো আর কি শুনানি হয়েছে না ক্যান স্কুলে অবশ্যই নম্বরগুলো কিন্তু দেবেন দিস ইজ আইটেম নাম্বারস 2 and 3 together heard submission made on behalf of the petitioners comma the applicants comma the state and the school service commission. The issue relates to the recruitment notification published by the School Education Department on 29th May 2025 for selection for appointment to the post of assistant teachers in junior high, secondary and higher secondary schools. Submission has been made by some of the applicants that the issue raised in the instant writ petition is pending consideration before the Honorable Supreme Court.
May use effectively pending.
The provisions of the rules namely the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes, bracket open, third bracket, except work education and physical education, third bracket close, comma, classes 9 and 10 and 10 and 12 and 11 and 12. Rules এর আগে bracket close, comma, 2025. Page number 79, এখানে রুলের নামটা আছে, দেখে নেবেন, ডেট আছে। Stop. The learned advocates representing the petitioners denies the submission. Stop. It has been submitted that not a single writ petition challenging the above rules is pending consideration before the Supreme Court. Stop. The paragraph, the specific issue that has been raised today is questioning the stage at which the 10 marks allocated for prior teaching experience is to be awarded. Stop. Whether the same is to be awarded prior to preparation of the interview list
Preliminary interview.
or prior to the preparation of the merit list. Please find out whether there is any description of preliminary interview
Yes,
list.
eight itself.
No, not 8. The definitions are there.
No.
Definition whether preliminary
The rule
list is there.
11 mentions preliminary in
Where is it described?
Rule 8.
But it is described
Sub
as
rule 8.
interview list.
Interview list.
Interview.
The sub 11.8. 11.8.
Is it prior to interview or post?
It's 11.8.
Further
Better.
issue that has been raised
Under 11 rule 8 says, all right. It mentions preliminary
is
list.
whether not whether is the justification of leaving out the in-service teachers of private schools from the realm of consideration of the selection. Stop.
Experience of secondary edition can be used in higher secondary.
The experience of using the experience of teaching students in the secondary level to be used as experience for teaching candidates, not candidates, students in the
Participant of secondary, senior secondary.
for in classes 11 and 12.
Whether 2016 appointees will get those 10 marks.
Stop. It has been highlighted that if 10 marks is added to the candidates who appear for teaching in level 11 and 12 to the in-service candidates, then the freshers will never get a chance to be appointed.
Yes.
Stop.
Another point argued whether 2016 candidates will get the role.
Rationality.
It has also been questioned as to whether the examinees whose selection in the year 2016 stood null and void by the order of the Supreme Court would be entitled to the benefit of 10 marks for the prior teaching experience. Stop. That apart, paragraph, the other points have also been raised, but the broad heads are mentioned herein above.
One more, the demonstration, 10 marks given at the time of preparation of merit list
and there's 10 marks for teaching experience. For the same reason, 10 marks again in demonstration. That's the rationality part I have taken.
Logic part, not the point.
To challenge that rules.
I am not going to all these. Paragraph একটা দিন. The parties are directed to exchange all pleadings and documents to be relied upon by them at the time of hearing, so that none of the parties is taken by surprise at the time of hearing. Stop. Copy of all intervening applications shall be exchanged. Stop. The parties are directed to produce documents in support of the submission that the issues framed herein above are pending consideration before the Honorable Supreme Court. The matter is fixed on the 12th of November.
That they will provide me the copies.
It is served. No issues. If not served, please serve.
My lord, only request, my lord, your lordship has been kind enough to record the commission submission also, my lord, that the writ petition is not maintainable at this stage, my lord. The point of maintainability be kept open. We have also cited judgments. Mr. Bandyopadhyay has.
The respondents issue regarding maintainability of the writ petition is being decided by the court, and it is kept open.
On the last line I have prayed for.
Last?
That I have prayed for, that result of the writ petition.
Yes. It has been brought to the notice of the court that the result of the written examination is due to be published today. Stop. As the issue is pending, as certain issues with regard to the awarding of 10 marks is pending consideration before the court, the result of the examination will abide by the result of the writ petition. Petitions. Everybody please.